The National Consumer Bankruptcy Rights Center, NCBRC, as it's known in the debtor bar. What do? How can they help debtor attorneys around the country and frankly create this precedence in law so that we can protect the debtor more and more?
So what we do in a nutshell is I take it from my own personal perspective. When I first did my own appeal in a bankruptcy matter back in 1997, there was no guidelines. There was no help for me to ask for. I basically had to kind of feel my way in a dark room and make sure that I hit everything. And so it was difficult. What NCBRC is here is to help people with that. Bankruptcy practitioners, we have a rhythm. That rhythm goes on it basically works with the 30 days after you file, you have a 341, you have a confirmation hearing, you have other hearings to deal with objections or other motions or adversaries that you file. And this is our calendar. This is what we're used to. Throwing in an additional element to basically handle an appeal, take care of the deadlines, make sure you have everything filed that you need to. It's just it's not any more difficult, but it's just a different type of way of practicing law. And fortunately, we have on our board some super smart people who are well known in the bankruptcy community, both consumer and also business. And we have people that are practitioners, we have people who are academics. The mission is to help debtors' attorneys, help debtors get the best possible result that they can on appeal.
So Jim, break it down as a non-attorney. I just want to, and we have a lot of new bankruptcy attorneys coming in
Sure,
to the industry.
sure.
Break it down for me. Like, why would a debtor attorney need to appeal something? I mean, from my naive stance, it's like chapter 7, chapter 13, and you're just processing the paperwork and moving it down the conveyor line. When would an appeal come up? And can you give me some examples of what that would look like?
Sure, you bet. Good example is a case that we had a good result on a few weeks ago out in the Ninth Circuit. And one of the promises that we make to our clients when they decide to file bankruptcy is that your debts will eventually be discharged. And discharged means that creditors can't collect on the debt. And I mean, if that wasn't around, then what are we pitching to our clients? And the only way that works is if the discharge is policed, if somebody enforces that discharge. So if a creditor comes in after the discharge, after they've been notified of the bankruptcy, and continues collecting, repossesses a car, garnish wages, they file a lawsuit. These are all things that happen occasionally, not often, but when we find out about them, debtors' attorneys, we have an obligation to police that. And the way we do it usually is fairly informally at first, talking to the creditor, trying to reach out to the creditor. But in situations, creditors just don't want to respond. So then you have to file a motion for sanctions for violation of the discharge injunction. So if you are in front of a bankruptcy judge who, for example, doesn't believe that your client should get emotional distress damages for having to deal with a creditor that just won't accept the fact that they can't collect on the debt anymore, then that has to be appealed because that is a major damage that clients have. People come in and they hire us as bankruptcy attorneys to relieve them of the stress of debt, right? That's the great thing about being a bankruptcy attorney is people walk out of your office and they're in a better mood than they were when they came in, usually. And if that discharge, after all the work that they've done, the money that they've paid, whether they're in a 7 or a 13 and they've gone through the process, done everything legitimately, and that creditor is still collecting, that's going to create a lot of stress.
Yeah.
And so we have to protect that. So in this particular appeal, the debtors council appealed it. And
so let me, just so I'm clear, in this example in the Ninth Circuit, the person filed bankruptcy, they got the discharge, and the creditor kept coming back to collect on some debt, right?
Exactly.
And the client kept on complaining to the debtor attorney. The debtor attorney finally said, hey, you owe my client money because you're emotionally impacting her.
Mhm. Right.
And the creditor spaced out or just didn't respond.
Well, the creditor responded,
Oh,
went
they
to
did.
court,
Oh, they did. Okay.
and the trial court said you don't get emotional distress damages for violations of a discharge injunction. And so the issue is whether or not you can get emotional distress damages for
Okay.
violations of the discharge injunction. So the stronger that discharge injunction is, the more protection the client has after the
Got it.
bankruptcy is over with. So in that particular case, we felt that it was, number one, important to get involved because
So the
if
debtor attorney came to Nick Brick, Jim Haller, executive director, and said, Jim, I don't think this is fair.
well,
And you
actually
learned
it
how did it
actually
happen?
in that case, we figured out about the appeal and we contacted them right
Oh,
after it was
really?
filed.
So
And they
you contacted them and
Yep,
you're like,
and
hey, we want to get involved with this.
exactly.
And then
And
you write the briefs or like what did Nick Brick do for that debtor attorney?
sure. So what we did is we talked about strategy, whether or not they should continue the appeal, whether or not it'd be good to go back to bankruptcy court. They decided that they wanted to pursue the appeal. So they drafted up their brief. They sent it over to us. We reviewed it, sent back with a bunch of suggestions. We lined up a big law firm in Los Angeles that had previously reached out to us saying, we'd love to have our associates write a brief. We'll have our partner take, basically captain the thing, but the associate will do it. So I got in touch with them. They said they agreed to write the amicus brief. We wrote an amicus brief and submitted that. It's due 7 days after the brief that we're supporting. So we submitted that. It went for oral arguments and we prepared a moot court, which is basically a practice court, practice oral argument. And we had an ex-bankruptcy judge, an ex-law school professor, the people who wrote the amicus brief, Henry Summer, and myself. And so we basically grilled debtor's attorney for about an hour and walked through what we thought were the good arguments.
Mhm.
And fortunately, we got a good result in that case. And so there's hours and hours that are spent. The concern I hear from some people is how much is this going to cost me?
Mhm.
And the answer is it costs you zero. This is a nonprofit. This is something that we do for the benefit of the bankruptcy community. And we don't get paid through the court. We get paid by donations. And I know you've made donations. You're a great donor and you've encouraged others to do that, but that's how we stay afloat. And so it's kind of a shoestring operation. I'm the executive director, but it's not a full-time job. I also have my own practice.
Yeah,
But it's
you're doing it for the love of the bankruptcy, the debtor bar. I mean, that's and the debtor
right.
community. And the practicality is the reason why you're looking and you're approaching this example, like you're going to them, because Nick Brick's committed to getting good case law on the books, right? So now in the Ninth Circuit, this is in the books, the decision's been made favorably.
Hmm.
And hopefully, if this happens in another circuit, they can reference the ninth, or you'll be able to, right? That's how that
Hmm.
works.
Yeah, absolutely.
Yeah.
So we're trying to create good precedent across the country, and we've submitted amicus briefs to the Supreme Court. There was a study done about 5 or 6 years ago that basically stated after the government, NCBRC and NACBA, which is our sister organization, submit more amicus briefs on consumer bankruptcy issues than any other organization.
Any other
It's
organization?
any other like bankruptcy, consumer bankruptcy
Right.
organization,
Okay.
like
Yeah.
the trustees,
Right.
or other groups. And
Right.
so we are kind of standing up and trying to basically equalize the playing field. I think one of the things that Tara saw, and one of the things I've always felt when I've taken an appeal, is that the other side usually has a lot of funding. And as bankruptcy attorneys, when we take appeals, most of the time those are done pro bono. We're doing them because we think we should do them. I've never been paid for an appeal that I've taken up. It's always been pro bono. And so you're spending your own time to do that. And the more help you can get, the better it is. The banks, the trustees, they have the funds to hire large law firms or hire an attorney who specializes in appeals. debtors' attorneys. We don't have that kind of
Well, I mean, just
money.
like this debtor in the ninth. I mean, the last thing she was going to do is spend tens of thousands of dollars fighting for emotional distress, right?
Right.
No
Yeah.
way. So,
Yeah.
Jim, how often do you guys like? How many cases are you involved in per year? Would you say?
I would say in an average year, we're involved in about anywhere between 18 and 22.
Wow.
So which doesn't sound like a lot, but that's
Well,
a couple of appeals every month that we
actually,
get involved in.
I mean, for the debtor bar, I relate to that. I mean, that's a higher number than I thought you were going to say personally.
Yeah.
And like,
Uh,
so if a debtor attorney's watching this and they have something that is like, well, this is unfair. I mean, wouldn't that be like the red flag of like, this is just not right?
hmm hmm
Basically NCBRC.org, National Consumer Bankruptcy Rights Center.org and just reach out and say, hey, I got this. How do you want people to approach you? What does this look like?
I am not a very formal person. So we have something you can fill out on our website where you can ask for advice or help on an appeal. I also take calls directly to my cell phone, and I also have an email just for, we call it NCBRC. That's the shorthand that we
Nick
use
Brick,
for
yeah.
NCBRC. Just
Yeah.
email me and I reach back out to you. We sit down and we talk, and then we figure out what we can do to help. There are some cases where if the issue is not something that is going to affect debtors across the country or in that circuit, we will still help. We'll still happy to review your brief, still happy to talk stuff. We may not submit an amicus on that case, but we will help walk you through it the entire way and help you prepare for oral argument. And we've done that multiple times as well. What I tell attorneys when I introduce myself is I say, number one, you're not alone. I've been in exactly the same position that you're in. And fortunately, there's a place now that wants to help you free, because all we're trying to do is just get the best possible result that we can for the debtor. That's it.
Yeah.
And it's the whole rising tide floats all boats theory. If we have a bad decision out of the Fourth Circuit, that's going to be cited in the Seventh Circuit where I practice, or the Ninth Circuit out in California. And so we try to make those decisions as best as we can. Sometimes we're asking the court to issue a ruling that is very narrowly tailored just to the facts of that case, because we don't want a big decision based on these facts. Other times we ask the court to make the big decisions and say, this is not right. And we don't take cases that we know we can win. We take cases that we know we need to fight. And we have been fortunate over the last few years, where I would say the vast majority of the cases we've been involved in have come out with a positive result. Now, a positive result in appeal means it goes back to either the previous level of appellate courts, or it goes back to the bankruptcy court for proceedings that are consistent with the appeal. Hopefully, at that point, the major issue has been resolved, and then it's a matter of just polishing things up. So, what I'd like people to know is that we're here. We want to help, and we have helped in hundreds of cases. And so, you're not alone. We're here. I never make our help contingent on, well, give us a donation and we're happy to help. We don't operate that way. I rarely ask people for donations.
Jim has a hard time asking people for donations, right?
It's a
I,
problem for me. You know what I
I'm
mean?
like,
And
Jim, this
yeah,
is good work, right? So let me point that out for those watching
right,
debtor attorneys, right?
yeah,
This is a resource for the entire bar,
yeah,
right?
yeah.
And the link will be in the description. If everyone can give a little bit, as Jim said, a rising tide helps all boats. You don't have to worry about unpacking it. He's got personal relationships in his cell phone for people in large law firms
Mm-hmm.
who will spend their time and their expertise in writing these briefs. And really, Nick Brick is on your side to give you the support, because most of our debtor attorneys, we're busy helping clients.
Mm-hmm. Mm-hmm.
It's impossible for us to pull this off or
Mm-hmm.
submit to the Supreme Court or an appellate court. This is what Nick Brick is for. Jim, I've known you since I was thinking about it. since 2012. You're
Yeah.
a staple in NACPA. You're a staple all over the bankruptcy community, always helping, and that's why you're so beloved in our association and our community.
Well, that's very kind, Phil. Thank you for saying that, and
Yeah.
thanks for
Great.
giving me the opportunity to talk to you.
Well, we're going to
So,
keep it going, keep spreading the word. We'll have all the information in the description. If you have any questions, reach out to Jim directly. Thank you, Jim.
sounds great. All right. Thanks, Phil.